Mr. Macharia.
If it pleases my Lord, the Chief Justice, the Deputy Chief Justice, and the judges of the Supreme Court, I will speak to the integrity of the electoral process, and I begin my presentation with addressing a question that my good and learned friend, Mr. Mahat, addressed you at length yesterday. I begin by affirming and adopting. I cannot use any more affirmative words to what Mr. Mahat submitted yesterday. And so I will not repeat anything he has said, but for the third respondent, we agree fully with everything that fell from his mouth. But as regards the register of voters, my Lord, I wish to draw your attention to the affidavit of a gentleman called Billy Atudo. Mr. Billy Atudo spends 16 paragraphs of his affidavit, running from paragraph 3 to paragraph 19, addressing the question of the register of voters. Now, as we submitted to you yesterday and the day before yesterday, that register has now been the subject of 3 distinct, separate statutory examinations. The first of those is the examination by the audit by KPMG, which was a statutory audit, and we've presented the report to you that was published, and the analysis by the IBC, which you will find at pages 94 to 110 of the affidavit of Mr. Davis Churchill. The second audit was on the 27th of June, 2017, when the register was opened up for public scrutiny again. And thirdly, Mr. Mahat did tell you, and I think I was part of that case, on the 3rd of August, 2017, the parties, one of the petitioners before you, or part of their group, went to court in the High Court and were granted orders for that register to be again examined. And so that has been examined 3 times. Now, notwithstanding that examination, what the petitioners did before you, and in annexing the entire report to you, they then rely on a report by their umbrella civil organization called Kurayangu Sautiyangu. And you'll find that at pages 136 to page 139 of Mr. Billy Atudo's register, affidavits. That is where the question of what they call the changing register of voters first arises. And Mr. Billy then spends the 16 paragraphs I told you about examining it. Now, what seems to have happened is that at page 19 of his affidavit, he realizes, or they realize, they made a mistake. And so they correct themselves about everything they've told you in their affidavits. So at paragraph 63, they close the affidavit. They say, I swear this affidavit in support of the petitioner's petition to nullify. So they close it. They then realize we've made a mistake. They reopen it. That the press statements by Kurayangu Sautiyangu are based on data that was available at the time. We note that they've made some mistakes, that we inaccurately recorded things in our reports. And he says, Kurayangu Sautiyangu noted missing serial numbers in Form 34B for Ndebes. This form does, in fact, have serial numbers. They correct themselves. They then correct themselves, and this is the point I was going to, about the voters' register. Though Kurayangu Sautiyangu noted that there were differences between the number of registered voters in the gazetted register and the announced register numbers, this was true, but the differences appear to have been due to the inclusion of prisoners in the county totals. That is the direct answer. They had skipped out prisoners from the register in their calculation. So please discount everything they've said in that affidavit on that subject. I then move on account of time, to the question of the register.
I'm sorry, I was just checking. You're reading from the same affidavit?
Yes.
So in one part of the affidavit, it says one thing?
Yes.
And then down the line, it reverses an earlier assertion.
Actually, on one part of the affidavit, it says many wrong things. And then at the end, it says the one right thing that cancels all the many wrong things. I then move on to the second point, and I think my Lord the Chief Justice did ask this question yesterday, and this was the question of the manual register that was available at all polling stations. The manual register is a requirement of statute, and you will find the provisions for that at Regulation 61, Sub-Regulation 4 of the Election general regulations. I know the ABC is telling me 69 here, but they're wrong, I think. I'm quite right, I know. I'm sure about what I'm saying. I'm looking at the regulations here. It is Regulation 61, Sub-Regulation 6.4a. I have it here with me. I then move on, and I had many things to say about the voters register, but time does not permit me. I will just direct this court, as I said, to the affidavit of Davis Churchill on that subject. But permit me to close that subject of the register with the provisions of Article 83 of our Constitution. Article 83 of our Constitution requires that in interpreting or in assessing any question as regards the conduct of the election or the registration of voters, we are to interpret it pro-voting. We are to interpret it pro the registration of a voter and not anti the registration of a voter. In other words, we are to encourage people to vote, we are to encourage people to participate and not to throw administrative roadblocks in their way. I then move on to a second point that deals with the question of this integrity, which is the question of the transmission of votes. As we said here a day or two ago, the provisions of Section 39(1)(c) require the transmission of votes of the forms electronically. And that was done, and that has been done in two ways. Number one, there are the forms that have been set up on the portal, and we do not require any further evidence other than looking at the affidavit of Mr. Billy himself. Again, time fails me, but if the court has some time, you will be able to look at starting at paragraphs 26 and going all the way to paragraph 35 and 34, where Billy Atudo indicates that he has obtained all 266 Form 34Bs from that portal. And so he confirms they are available on the portal. Number two, the chairman of the IBC did keep us updated on the day he announced his results as to the number of forms that were coming in through this electronic system. And again, I can confirm, and we have indicated in the affidavit of Winnie Goshu, where that website is to be found, where you can then interact with all these forms. And I need not read that out fully. Now, there was an interesting development this year. The IBC invited the media to take time to go and record what was going on at the 290 constituencies. And one TV station did do that, and we've indicated that. You will see that at paragraph 32 of Winnie's affidavit. Citizen TV recorded the announcement of all results at the 266 constituencies. It's not a matter of public relations because Article 86 of our Constitution sets up a hierarchy, and because what is being attacked here today is the constitutionality of the election, it is important to understand that Article 86 has three requirements of the IBC. The IBC is, number one, to count. That is Article 86. Number two, they are to tabulate in a prescribed form. That's Form 34A, B, and C. And thirdly, and this is the point I make with the Citizen TV initiative this year, they are to announce promptly at the polling station. And one of the decisions the Court of Appeal made in the minor KI case was that once that process is complete at constituency level, it is final. It ends with an announcement. I have searched for the allegation in this petition that an announcement differed from what was recorded in the form. There is not a single one. It is the same thing, Article 86 of Article 3, I believe it is, that the IBC is to openly and accurately collect and promptly announce at the tallying center the results that it finds. Now, in the affidavit of Billy Atudo, and I believe this is paragraph 29 of his affidavit, he complains that the results came too quickly. Now, that is a complaint against a statutory imperative. The Constitution says you have to do it promptly. Now, when we were last year on the 1st of September or the 8th of August, the complaint was that they came too slowly. And so I feel sorry for my friend, Mr. Mahat, who says his client has become a punching bag. He can't do anything. When he does it too fast, it's a problem. When he does it too slowly, it's a problem. And so I think we ought to dismiss some of these things. But to just make a point, the voters in Busia Women's Prison, there's only one voter there on the register. And on the 8th of August, unfortunately, her vote was rejected. Now, there is absolutely no reason why within 15 minutes, the returning officer or the presiding officer should not have filled the form and put it on the KIMS kit and sent it to Nairobi. It should be here in 15 minutes. And so I suppose that deals with that question. I then take up the point again made up by Mr. Billy Atudo at paragraph. There's a long table which begins at paragraph 33, which is at page 11. At page 11, he says there are no serial numbers on certain forms. Now, he does not indicate which those forms are. He says there are 6 of them, but he doesn't tell us which ones they are. He just says there are 6 of them, unidentified. But we have taken the time to go through each and every of the 266 forms on the portal, number 1. Number 2, forms that were given to us at the polling stations, and we can confirm that all of them have serial numbers, all of them are stamped, all of them are properly recorded, and all of them are signed by the electoral officials. A small point, but I think it goes to make the point that you can't trust the numbers the petitioners are putting before you. At page 12, Mr. Billy puts a table. It's on the second half of that page. My lords, that's page 12 of Mr. Billy Atudo's affidavit. He does accounting. He says the forms do not have a takeover section. He adds 0 plus 0 plus 266 equals 291, a clear error. Now, this is the evidence before you. This is the evidence you are being asked to take and annul an election. I would humbly ask this court to reject this evidence. I move on to another point as regards the question of the integrity of the numbers. And Your Ladyship and my lords, at page 90 of the affidavit of Winnie Gushu, we have set out a table, and I say this because of lack of time, that gives a blow-by-blow response to everything that Billy Atudo has said. They have then taken up another point on the question of forms. There is an affidavit that indicates that there are unclear forms. You will find an affidavit by a gentleman called Brian Omwenga, who saw our affidavit. This was the question of the KIMS kit taking photographs. Mr. Omwenga has indicated with clarity why each and every of the forms cited there had difficulties, and he has also attached the form, we got the physical form, showing that there was absolutely no problem. But in resolving these questions, and this is a respectful and humble petition to the court, please consider the provisions of Section 72 of the Interpretation and General Provisions Act. Please do also consider the provisions of Section 26 of the Statutory Instruments Act, which is in similar terms to Section 72. And finally, please do consider what this Honorable Court said at paragraph 133, paragraph 133 of Raila 2013, where you took judicial notice of the fact that some of these forms, photographs and that kind of thing, are taken in dimly lit corners of Great Republic, but where power is a problem, and so it's dark sometimes, and there are problems of that nature, and you took judicial notice of that fact. I move on from there now to a point, I think that, please permit me 2 or 3 minutes to say something about the attack on the appointment of returning officers. On the 25th of October, while we were seated here waiting to hear a case, yet another case by the second petitioner here, I believe on that occasion he was trying to stop the election. I think we were watching TV and noted that there was a decision being handed over at Milimani concerning the appointment of returning officers. You will find our answer at paragraphs 98 to 104 of the affidavit of Mr. Davis Churchill. Now, one, that case was heard without notice to us. We were not invited to be party to that case. And that was a requirement of the provisions of Order 54 that deal with judicial review orders. Any party directly affected ought to be invited. It was not the first time a similar case had been brought. We had had another one prior to the 8th August election, and in that one, we participated. Now, it makes a difference because in the one before 8th August, we actually recorded a consent on that issue. So it wasn't an issue during the general election. Unfortunately, this time, for some reason, we were not invited. Number two, the provisions of Regulation 3, Subregulation 2, must be read as circumscribed by Regulation 89 of the General Regulations. It's an important regulation because Regulation 89 says that the regulations are to be applied to a fresh presidential election with such adaptations and modifications as are necessary, because it's not like a general election. So it is different to that extent. Number three, the petitioner in that case, so the applicant in that case, who's the second petitioner here, indicated in that case that the parties he had consulted to find out whether they were consulted, because it was a consultation issue, were ODM, ANC, and Chama cha Mzalendo. He went and consulted the parties who had said there will be no election, and did not consult the ones who said there will be an election. And so there's a bit of irony there, and an injustice. They didn't come to ask us, and none of the other political parties, none of the other independent candidates have said they had a problem with these appointments. But the party that didn't want an election goes to court to say they have a problem. And so please do consider that when you review that particular point. Now, there was an issue that arose in Judge Mativo's decision in the Uhuru court case that has some relevance to this question as well. And it dealt with the question of the absurdity of forcing dates in a contest that had constitutional timelines and made it impossible to do so. And so please, again, do consider that point. And a very important point, and you will find this in the letters attached to Davis' affidavit at page 40 and 41. The second respondent, the chairman of the IEBC, did in fact call us for meetings to discuss all these things. We were called for what was being called stakeholder engagement. And the problem was, one party said, the only thing we can come to discuss with you is your resignation, number one, and whether there will be no election. And it became very impossible for this consultation because Rule 3.2 deals with consultation. But the parties being called to be consulted do not want to be consulted other than firing you. And so again, please do consider that when you retire to write your judgment. My time is beginning to run out. The court, I'm told it has run out a long time, but my senior, Mr. Ngatia, I think had asked me to mention a thing or two about the provisions of Article 138 and 136 as regards disenfranchisement. One sentence. Remarkably, our Constitution and the Elections Act do not tell us what an election is. They tell us, they describe it. It is a presidential election, it is an MP's election, but they don't tell us what it is. And so we found a decision, and you will find that in our Digest of Authorities. It is a decision, I think, cited at, it is decision number 34 in our Digest of Authorities. And this is the case of Peter Anyang' Nyong'o and 10 others versus the Attorney General, where a similar question arose: what is an election? And what the court on that occasion said, this is the East African court at Arusha, they said that an election connotes the word choice. Therefore, under Article 138, sub-Article 2, and under Article 136, the reading then would be, using that definition, that an election is the opportunity exercised in a process regulated by the Constitution and the law for citizens to exercise their sovereign choice of their representatives. In other words, when the IEBC has presented the opportunity for you to exercise your choice, an election has been arranged. That is what that definition would draw us to say. I would have said many things. Allow me to end with these 3 sentences. The decision that confronts you is a decision as to whether, going forward, Kenya will be governed by the rule of law or by the whims of man. Whether Kenya will be governed by constitutionalism. And as my learned senior said, the pacific resolution of disputes. Or whether, as Justice Mativo said in his judgment, we will succumb and surrender to vigilantism. Those are words used by Justice Mativo. And finally, the words of the Court of Appeal in a case called Abuchiaba. You will find those in the affidavit of Davis Chirchir in response to the affidavit of Nasanga Aki, where at paragraph 13, we cite a well-known principle that, and I'm quoting directly, I know that this is Justice Omolo, I believe, saying this. I know that the law has often been said to be an ass, but I equally know that the law cannot be such an ass that it would even forget its well other known principle, namely that no man can be allowed to rely on his own wrong to defeat the otherwise valid claim of another man. My lords, do not permit those who wanted to kill an election to kill a second election. I rest my case unless the court has any submissions or any questions for me.